What are the defenses for vehicular assault and vehicular homicide in Ohio? I'm Shawn Dominy. I'm a criminal defense lawyer in Columbus, Ohio, and this infographic is going to answer that question. The defenses for each case must be tailored to the unique facts of the case, but there are common strategies for these cases. Those common strategies can be divided into three main categories. One, defenses to the allegation that your driving caused the accident. Two, defenses to the allegation you were under the influence. And three, defenses to the allegation you were over the limit. For charges of vehicular homicide and vehicular assault, the prosecution must prove your operation of a motor vehicle caused serious physical harm or death. That means the prosecution must prove your driving caused the collision. For proof, the prosecution relies primarily on accident investigation and accident reconstruction. Accident investigation is the collection of evidence at the accident scene. Mistakes made during the accident investigation can lead to incorrect conclusions about how the collision occurred and who caused the collision. Accident reconstruction is the use of scientific methods to ascertain how the collision occurred and to determine the cause of the collision. Although scientific methods are used, they are applied by people, and people make mistakes. Sometimes the mistake is overlooking possible causes of the accident due to confirmation bias. If a person has a preconceived idea about the cause of the collision, he or she may fail to consider other explanations and may ignore evidence inconsistent with the preconceived conclusion. Other times, the mistake is related to the application of mathematical equations, computer-assisted formulas, and technological resources. Finding mistakes in accident investigation and reconstruction often involves the services of an accident reconstructionist for the defense. Now let's talk about defenses to the allegation you were under the influence. For charges of aggravated vehicular homicide and aggravated vehicular assault based on the charge of OVI, the prosecution must prove you operated a vehicle under the influence or over the limit. To prove you were under the influence, the prosecution introduces testimony of witnesses, primarily police officers. Some of the defenses to being under the influence are based on your driving and your initial contact with the officer. This is a list of those types of defenses. Other defenses are based on field sobriety tests and drug recognition evaluations. The defenses attack the admissibility of the tests, as well as how much weight should be given to the tests if they are admitted. Next, we have defenses based on the driver's conduct and circumstances. Sometimes there's evidence we would expect to see when a driver is under the influence, and that evidence is not present. It's not only the driver's conduct and circumstances which may form a defense. Defenses can also be formed based on the conduct and circumstances of the officer. One piece of evidence prosecutors use is the driver's refusal of a blood, breath, or urine test. As you can see in this slide, there are multiple defenses regarding the refusal of a chemical test. This slide shows defenses based on legal concepts. These may apply to both the allegation you were under the influence and the allegation you were over the limit. Now let's talk about defenses to the allegation you were over the limit. For charges of aggravated vehicular homicide and aggravated vehicular assault based on this allegation, the prosecution must prove you operated a vehicle with a prohibited concentration of alcohol and/or drugs in your system. To prove your alcohol and/or drug level was over the limit, the prosecution introduces results of blood, urine, or breath tests. The defenses in this section are intended to exclude the tests from evidence or show why the test results were inaccurate. This slide and the next one illustrate 20 different defenses we use for breath tests. In this slide, we're assuming the breath test is going to be admitted as evidence, and these defenses are showing why the breath test result may be inaccurate. Listed here are examples of ways we get breath tests excluded from evidence. These are based primarily on the police department's failure to comply with Ohio regulations for breath testing. Blood and urine tests involve some defenses which are different from those for breath tests. Blood and urine tests are conducted by gas or liquid chromatography rather than infrared spectrometry used for breath tests. Blood and urine tests also require law enforcement to have a search warrant or a recognized exception to the search warrant requirement. There are two general categories of defenses to blood and urine tests. The first category involves ways to have the test excluded from evidence. If the test results are admitted as evidence, the second category involves strategies for attacking the accuracy of the test results. There are a couple of important things to keep in mind with these defenses. First, not all of these defenses are going to be used in one case. Our defense needs to be individually crafted for each client's facts. Second, the defenses discussed in this infographic are not all of the possible defenses for vehicular homicide and vehicular assault. We only included the most common defenses. As you can see, defenses to vehicular homicide and vehicular assault can be complex. In these cases, it is important to be represented by a lawyer who is knowledgeable about the defenses. The lawyers at the Dominy law firm understand how to form defenses and how to present them in court. If you're seeking representation for the charges of vehicular homicide or vehicular assault, you can schedule a free phone consultation with a lawyer from our firm by calling the number on the screen or by completing a contact form on our website. In any event, we hope you find this infographic has been helpful.